We are going to tackle question 4, 5, question 4 and 5. Those two questions. But before that, you remember what we talked last time, eh? You are supposed to draft some things and share. You are supposed to draft something in question 3. Were you able to draft?
I was able to draft.
Yes.
I had just gone to the shop. Let me get home. I can share it with you. But I had a question.
Yes.
When you do, like for instance, this reference, it was supposed to be we were applying for extension of time so that we can file our reference.
I can't hear you.
Can you hear me now?
Yes, I can hear you.
I'm asking, when you're doing, we've not yet covered it in my class,
Yes.
but when you're doing an extension of time,
yes.
you do that application separately and then you do your substantive application separate, or do you combine it?
You combine them, eh? You combine them. You remember the question that we had, the one that I projected, county government of Tana River. You say yes. That the draft reference Drew Echebasamos is attached. So you draft them. You say that it is attached to this application. First of all, you say that you are seeking for leave. Eh? Are we together? And you know this question was only 5 marks. Eh?
Yes.
This question was only 5 marks. So you just draw and say that you do miscellaneous reference in the High Court of Kenya, miscellaneous reference this and this number, the parties, let all parties meet in the chambers. You know how the chambers must look. Then you say for the following orders, that leave be granted for the applicant hearing to appeal the decision of a tax master out of time. Then the draft, the cost, the application, the grant of leave B, a prior stay of execution of the taxing master decision. Then the cost be provided. Then you do a very, in fact, this question being a 5 marks, you don't even need to do an affidavit. Affidavit. Chamber summon is enough. Unaona? Are we together?
Yes.
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 And your internet is low, eh? That's what it's telling me here. You can share later.
Okay, I'll just send it to you.
Okay, You can share it through WhatsApp.
Okay.
I am trying to get some readings from the courts from law firm, but I've not been successful. But I'm still going to. I'm looking for them. I'm going to find them with the time. Some of these things you are not quick, because you see, when you offer people money, they will give you. But because you don't want to offer people money, I want to get them through friendship. Those people who work with, I'm going to fight it with the time. Because if you say everything you are going to give money, where you get all this money to give people? You saw I requested in the groups, but if I could have offered some money, I could have gotten it. But I'm going to get it, and I'm going to share it with you, because also I need the pleadings for future. And I just, this morning I was looking at this civil litigation results, and I realized that this was one of the questions that was, the people failed this paper. It was second most failed paper by recent students, and regular it was second. So it was not an easy paper. I was looking here at your, this is your course lifetime I'm projecting. Where have you reached in your civil litigation course outline? Topic which topic? You are doing which topic now?
I'm in class F. We dealt with reviews the last class and started on appeals.
Yeah. Okay. Review started of an appeal. And you, Ruth?
We're in those execution for decrease.
Execution of decrease. So execution of decrease is topic 12. So it
Yes.
seems you are a bit back. Review appeal, that is topic 13. Then appeal, that topic 14. You have judicial review to go. Constitutional litigations. Then cost. Then procedures before tribunals. Those are top 4 topics. I hope you'll be able to finish before you break. You have like 1 month for your studies. I know they are going to give you around week, 2 weeks to study for your exams. Your calendar is ending at, I think it is ending the 2nd week of November. Sawa. So, you are going to look at this question 4 and 5. And 6 we are going to look next time, because there are some things I'm still researching and fine tuning. So question 4, Morris Wilson of your box this Nairobi and 17 others were employed by Caron Limited of P.O. Box, that a government parastatal, in various capacities. The initial employment was casual terms for diverse periods of 2 to 3 months. In 2008, upon lapsing of the term of the 18 workers, continued in employment of the company without any interruption. The workers were members of national security funds and permanent staff, and company made deductions from their pay and remitted the contribution to the fund on their behalf. The company required the workers who have acquired permanent status to convert their status to casual status by signing letters of employment on casual terms of service. In September 2022, after long periods of non-payment, the company offered to pay workers part of their paid salary as full and final payment up to date of the payment. Upon acknowledging the payment, the company would offer the workers contracts, converting the employment status from permanent to casual. The conversion would be subject to the following condition: that the conversion would be for a specified period or not exceeding 3 months from the date of commencement. The wages would be determined at a daily rate. The workers would perform their side duties to the satisfaction of the company, failing which the services would be terminated. The workers who do not have any other claims against the company apart from wages, and that the employment on casual basis do not guarantee confirmation to the employment on permanent basis. The workers who are considered as permanent rejected the conversion of employment contracts. The company involved police to force the workers to sign and accept the conversion contracts and get evicted from the houses provided by the company. Subsequently, the company locks the workers from past October 2022. The workers contend that their rights are protected by Article 10, 41, 232 of the Constitution, have been violated, and are keen of seeking legal redress against the said violations. You have recently registered a firm trading as Pembo and Pembo Associates, Wajiri House, Faithful Pew Box, that box, Nairobi telephone, email, thus. The workers have given you above facts and equations, send them to advise them if they have a valid claim and chances of success. Amongst the difficult question in this paper, I told you the paper was not very easy, and the results which I release can show. But amongst those questions, this question 4 was one of the easiest one could do and get good marks. What are the keywords here, Marianne?
There's a number of employees, so it's actioned by a number of people. Then there's the violation of constitutional rights, Article 10, 41, and 232. Then there's the aspects of the Employment Act with the forceful conversion. Yes, those are the ones I can see.
Okay. Sawa. That is very true. This was you can add your volume on your side, eh? I can't hear. You are not as clear as other days, eh?
Okay, sorry. Can you hear me now properly?
Yes, you have. I can hear you, but it is the volume.
Okay.
Add for some volume kidogo, eh? So, this question, is on constitutional violation and employment rights, eh? And of course, you have not covered constitutional litigations, eh? Labor rights under Article 41 are fundamental rights and freedom. And they have been under 2010 Constitution. Now they are labor rights are constitutional rights. So the question is asking you, advise them. Those are the keywords on the valid claims and chances of success. So this question requires you to discuss the fundamental rights and freedom, knowing your constitution. Know your constitution very well, because if you know your constitution very well, you'll be able to do a lot of things. Even in criminal, for example, fair trial, Article 50, right of an arrested person. You'll be able to deal with questions in criminal and civil. So, what does Article 10 talk about, Ruth?
And national values and principles of governance.
Good. Which are national values? Constitution is a very basic thing you should know. Article 41 is, of course, labor rights. Then, Article 232. Miriam?
Values and principles of public service.
Yes. Yes. So, you start by saying that articles of they have valid claims, values of and not just for this question. If a question has come both in criminal and civil. If you know these articles, you'll be able to answer this question very well on constitutional violation, on constitutional violations. The national values and principles, Article 10, bids any person, whether in public or private, when he applies the Constitution. Rule of law is one of them, and here they have infringed the rule of law by converting the status of their employment from being permanent to casual, using the police to force them to harass them, sending them forcing them to sign contract, ejecting them from the houses. So the national values, which you can use in any given civil litigation or criminal or rule of law, participation of the people. If you are given a question where there was no public participation, you can use Article 10, human dignity, inclusiveness, accuracy, human rights, non-discrimination, good governance, integrity, transparency, accountability. Those are national values, which you bid every person, whether in public or private. Then another article is human dignity, Article 28. When they are being, all these things are being done to them, their human dignity is being infringed, Article 28. An article that is easy for you to get and use in your exams. Another common article you can use is Article 30, against slavery, substitute, and forced labor. That is self-explanatory. Then another article, of course, is forced labor. Is right to fair labor practices, 41.1. And here you can say reasonable working condition. Then Article 43 on economic and social rights. Remember, every employer has a right under the Employment Act to give housing to his employee, or give an allowance, housing allowance to cater. If they don't give housing allowance. But here, they were evicted from houses. So their right to housing and Article 43, economic and social rights, were infringed. Then another very good article you can use is the right to fair administrative action. Before any action is taken against a person, you should suspend them to a fair administrative action, which is expeditious, efficient, lawful, reasonable, and procedural fair. When all these things that were being done, can we say that there was fair administrative actions? These articles, I'm quoting them, they are very popular. If you get them, you are going to be able to do them both in civil litigation and criminal litigation. For example, when you are told that someone was arrested, he was from March, he was not, the family could not access them. These are our articles you can use in your criminal. Article 48, access to justice. A very other popular article. Then you go finally to Article 232, because this is a parastatal. You say that under Article 232, the values and principles of public service are high standards of professional ethics. So when they were being, when these things were being done to them, can you say that they are professional? These parastatal were professional. Article 232. Then, on the second bit of the question, the chances of success. You start by saying that Article 22, they can move to court of the Constitution. Right to institute proceedings. They have right to institute proceedings, claiming a right to a fundamental freedom have been infringed. Denied or violated. Then you discuss Article 23. They file that constitutional petition in the Employment and Labor Relations Courts because there is a labor matter. And the Employment and Labor Relations Court have a power to hear constitutional petition. You can look at the Act, Employment and Labor Relations Act, where it gives powers to Employment and Labor Relations to hear constitutional petitions. There is a section there. And after the court listens to the case, they can give various orders, including declaration of rights, conservatory order because it's a government decision, order of compensation, order of judicial review. You discuss all these things. There is a case here, a very good case called Kenya County Government Workers Union, Kenya County Government Workers. Versus County Government of Nyeri. It is a 2015 case. Which have almost the similar facts to this case. Remember, in civil litigation, cases are very, very important. Marianne.
Yes.
Is there a limitation of time which you should bring a constitution petition?
Yes. No, I don't know. I think the one I thought immediately was against government. I don't know about constitutional. I'm sorry, I don't know.
Okay. Ruth?
I don't think so.
Yes, that is the correct answer. The constitutional petition do not have limitations. When you are claiming a breach of fundamental rights and freedom, they don't have limitations. And that's why, even if the violation happened 100 years ago, that is the beauty with the 2010 Constitution. You remember the soldiers of 1982 who were dismissed from jobs after the COP, 1st August 1982. They brought many constitutional petitions after the 2010 constitution, seeking violations of their fundamental rights, and they were awarded some money. So there is no bar to constitutional petition. That's why I was telling you, in an exam scenario, unless you are told to bring a judicial review expressly, unless you are told to draft a judicial review application expressly, because a judicial review application must be brought within 6 months, of course, of action. Under Order 53. The best thing to do in an exam scenario where there are violations, it is to do a constitutional petition, because there are no limitations. Unless the question now tells you these are judicial review, what do they have to do to seek leave? Then after being given leave, now they serve. So that is if you are told to draft a case which involves violations, don't do judicial review unless it is expressed. The question is expressed. The safe way to go is constitutional petition, which, because it does not have a limitation of time, and it's easier to prove in court violations because the threshold is very low, unless in judicial review. So this case, county government of Workers Union versus county government of Nyeri. These people, of course, all these articles we have talked about are here. The facts of the case are the respondents engaged, which is the Nyeri County government and the County Public Service Board. Members of the employees are engaged on diverse dates and assigned duties of a permanent nature. Each employee have performed for a long time on permanent basis. Despite demand to place the employees on permanent terms and condition of service, the respondent failed to do so. Unaona? They refused to put them in a permanent basis after working for a very long time. So they went to court. So, and the orders that were given were as follows. The orders restraining either the respondent of themselves terminating the employment of the petitioners, herein purportedly as casual employees, would be unlawful. Orders restraining respondent from employing or employees in the same position, the same or similar as the petitioners' members. The order stopping the respondent from terminating or dismissing the petitioners' members from the respondent employment without following the law and their terms and conditions. The conversion of term of service of the petitioner's member, herein purportedly being casual employee in service to the respondent on terms and conditions of service consistent with the Employment Act. The declaration, you see, one of the court can give is declaratory right. The declaration that the respondent violated the petitioner's members' rights herein of labor practices, namely reasonable working conditions, including minimum terms and conditions of service protected under Article 41. The respondent to pay petitioners' cost. So these are cases you can use and look at it later. And in your exam, you can be told to draft a constitution petition. It has been tested in the past, and is a very popular area, both in criminal and civil matters. To draft a constitutional petition, you can be told, and this is how you coach your prayers and orders. And that's it. This was one of the is a question one could do. The high school student did this question, and she did well. I think she got 8 marks. It was not a very difficult question. Your homework is you go and look at timelines and the rules. I told you timelines are very, very important in civil litigations. When a person is supposed to reply to a petition, you can be asked a question on that. I have seen people being saying that basic leave to reply to a petition out of time. The workers would have valid claim. They have a cause of action for contravening and infringing their rights. The workers can file a constitution petition in employment and labor relations specific court, stating their rights have been infringed. Article 23 provides High Court have a mandate to hear. That one we have discussed. The declaration that can give a High Court can give very, very important declaration of rights, conversation, judicial review order, and injunction. Article 41 on labor rights. Yeah, and the others that I gave you. So she got we don't know if he's a he or she, but he tried. This was not a very difficult question. It was doable. On all the questions that we have tackled, I think this was the easiest in this paper. So if I was doing this paper, this is a question I could have started with to build confidence. So we go to the next question.
Mwalimu, before we proceed, I had a question.
Yes.
How, if when I'm looking at a question, how do I, okay, like a constitutional petition, there has to be a contravention or like an infringement of a fundamental right. But how do I distinguish that from a class action and a representative suit?
You know, what is the meaning of from your meaning, from your research or from your class? What is a representative action of a class action suit?
The one I know is representative suit is usually where you're representing maybe a group of people who have the same common, they're seeking the same common action so that you stop like there being multiple suits about the same case. So I've realized like in this case, it's both a constitutional petition and it's a representative suit because you're representing the 19 workers. Class action, it's usually because it affects a specific group of people. That's all I know from a class action.
Now, you see, you know what you are talking about, representative suit. Of course, how you have defined is correct, or class action suit. Representative, you are representing many people, and you are of course multiple suit. Then class action, you are bringing for a class number of people. Unaona? For example, an example of good class action, you remember the interest rates by bank when they were adding interest rates without consulting the people. So there was a people, they are being told to sign some petition so that they can bring a class action suit against people. But both of them are in civil litigation. Are you getting? Those are things which are in civil procedure or civil litigations laws, civil litigation, civil procedure law, and constitutional law also is another area of law which is different from civil litigation. You know that?
Yes, Mwalimu.
So, and of course, you know there are various areas of law which you run in civil litigation. But when you go to practice, you find, for example, if you have a representative suit or class action, you're going to file it in civil litigation division of the High Court or magistrate. But in the constitutional petition, you file them in the High Court, Constitutional and Human Rights Division. So, unless the question, of course, this one also can be done as a representative suit, but this question has not told you this. You see, that's why I was telling you, unless the question has told you expressly, you do a representative suit. You now do those things you are saying. But this question is telling you very clearly, the workers, their rights have been protected, violated, seeking legal redress against those violations. It's already telling you this is a constitutional petition. In constitutional petition, there is no things like representative suit. Of course, under Article 22, you can, a person can act on behalf of another person who cannot act on their own. You see, a person acting as a member of an interest or a class of persons. So that is Article 22, 2A and B. So of course, one of the workers can act on behalf of other people, but you don't call that a representative suit. A representative suit is purely on in civil litigation. The correct way to say it is you quote Article 22, 2A and B. Are we together?
Yes, we are together. And just out of curiosity, how do you when you're doing, I've understood like constitutional petitions are obviously a petition, but representative suits and class suits, is it just a normal plaint or is there a specific format for it?
It is a normal plaint. It is a normal plaint, but that is subject to, you can confirm here. Yeah, this suit is a representative to suit commence under order 1 rule 8. You can look at this order 1. Order 1 rule 8. One person may sue or defend on behalf or the same interest. Order 1 rule 8 is the basis of representative suit.
Thank you, Mwalimu.
Yeah, and your audio now is okay. Where numerous persons have the same interest in any proceedings, the proceeding may be commenced and let court otherwise orders continue by against one or more of them as representative or presenting or except one more. The party to in such case give notice to the suitor or such person either by personal service, a number of person or any cause. Such service shall not be by public advertisement. Any person whose behalf a suit is instituted or defended under 1 may apply for court to be made party to the suit. So, to the best of my knowledge, you see, for example, Rose Florence Wajiro. I can share. Rose Florence Wajiro versus Standard Bank. You see, Wajiro, Rose Florence Wajiro, suing on behalf, you must say this, all person interested, past beneficiary account holders No, because all these people were all account holders in the standard. It was being, this is a suit or representative suit commenced under Rule 1.8 of Civil Procedure Rule. Because we share a community of interest. Notice of Nini. So they were contending the how the Nini this notice, how you should proceed when you are representing people. So these were the order. The properties shall within 7 days submit to court for approval notice public advertisement done in accordance to. So you must advertise that you are what you have read in order 1 read. The Adam provided in the application, so he had not done correctly how proper when you are representing people. Of course, it's a plaint versus the defendant. It is commenced by a plaint. Are we together?
Yes, thank you.
Yes. So this is something is a case you can be. This area you can be asked. So thank you for that question. But this is purely civil litigation. Unless you are told in a question this is a representative suit, that this now how you should do those things. But this question was talking on a constitutional petition. You are bringing what you are bringing. If you are bringing against for other persons, other workers, you quote Article 22. So we now go to question 5. This question was not easy. It was one of the difficult questions on this paper. On 17th June 2022, the Employment and Labor Relations Court awarded Judge Mercy a sum of 1,974,531 against Tapsop PLC. On 30th June, her advocate presented a decree to court without notice to the respondent advocate. The deputy registrar of court signed the decree as done since it was an agreement with the judgment. On 20th July 2022, advocate having received the signed and sealed decree, applied for execution without ascertaining the cost payable to her. The warrant of attachment and sale were issued to shorter auctioneers who attached the respondent's properties on 30th July 2022. I told you in civil litigation, timelines are very, very important. In fact, we are going to have a session that is very, very important before the exams to discuss the timelines in various applications, because most of these questions in civil litigation will test you about the timelines. If you, in any question, civil litigation, most of they will ask you about the timelines. You cannot, if you cannot see the timelines, you will not have gotten that question. If it is judicial review, what are the timelines? Constitutional petition, employment, labor relations, appeals, all those things. Prepare a table on all those things. The timelines, very, very important. And we are going to look at some of them. I'm going to prepare something on the timelines. This is why they give these dates, because they are testing you on these dates. So on 5 August, the respondent advocates filed an application under certificate of urgency seeking stay of execution. And I also told you in our last class, unless stated clearly in the paper, when you are told to advise or do something, you advise at the date of doing the exams. So that is the day you look at the time unless the question, of course, tells you expressly, you advise as at this day. But the default is you look at the date of the exams and advise if the timelines were followed. On 5th August, the respondent advocates filed an application under certificate of urgency seeking stay of execution of decree and review of the judgment of the decree. The respondent relied on grounds that they have not been given notice before the decree was extracted, and they discovered that the claimant had been advised alone while she was employed on the respondent, and the amount of 356,200 was still outstanding, among other grounds. The application was placed before the judge, who declined to grant the interim orders but certified this as urgent and directed to be served forthwith for hearing inter partes on 20th August. The respondent is dissatisfied with the services. Of course, we are not told inter partes hearing 20th August. The respondent is dissatisfied with the services of its advocate and approached your law firm to take over the conduct of this matter and prosecute the application. However, before the respondents formally instruct you, it requires a legal opinion on the issues raised in this application. Write a legal opinion on the legal issues issued, raised, and the merits others of the application. So, in brief, this person, Jane Massey, was awarded those sums. Of course, it was a labor dispute against TAPSO PLC. Then the advocate drew a decree without the respondent's advocate, TAPSO PLC, which you are now advising. The deputy registrar signed the decree as drawn, since it was agreeing with the judgment, but they had not consulted the respondent advocates. Then this advocate for the claimant proceeded to execute the decree without ascertaining the costs payable to her, to them. Then the warrant of attachment and sale was issued to Chota, who attached the respondent properties. Then on 5th August, the respondent advocates filed an application under certificate of urgency seeking to stay the decree and review the judgment and the decree. The respondent relied on the ground that they were not given notice before the decree was extracted. They also discovered that the claimant had a loan with them and still was outstanding. This application for stay was brought before a judge who declined to give it interim orders, but certified this as urgent and directed to be served for hearing inter partes on 20th August 2022. So the respondent was dissatisfied with the advocates. That's why he appointed you to prosecute the application before the judge. Of course, this means that on 20th August, it did not proceed, because this is the application now you are prosecuting. because now the exam was being done in October. We presume the application, the inter partes hearings did not proceed. He needs a legal opinion on the issues raised in the application before, of course, you go for inter partes hearing. So this is how you interpret and understand this question. So I told you, when you're told to do a legal opinion, you do a legal opinion in your legal writing and drafting class. The question is 10 marks. Don't waste your time so much writing facts. Facts are already in the question. You go straight to the issues. Legal issues identified. Then you give your analysis and the conclusion. So, what are the legal issues here? You can see, Ruth.
Okay, the first one is the issue of decrees, not the fact that it is only one party that wrote the decree, then without the president of the other one, because I know either the deputy registrar is the one who's supposed to write, or the parties can sit down and formulate their own decrees, and then bring it to the registrar for her or him to approve of it. Then there's the okay. Okay, here on look at the 20th July. Once they got they applied for the execution without ascertaining the cost payable to her. So even that is an issue. Now, how do you sell a property without knowing how much you're supposed to have, according to me? I think a decree should be very specific. Look for another one.
Yeah, so those were the two issues that this question wanted you to discuss. The first issue is that these people went to court to have their decree signed before, without involving the other people, the respondent advocates. Then they executed, they purported to execute the decree without knowing the cost payable to them. Then they also, the third issue was that they did not disclose that this person, Jane Massey, had a loan. So because he had a loan, they ought to have declared that in the application for execution of a decree. So that money can be deducted in the decree. For the now they get the balance. Those were the three issues. And as Ruth has said very well, and now I want to remember every issue, these are legal issues. When you are doing your analysis, you must know the now quote the law which you are supporting in your legal opinion. And now I want to sorry?
I have a question.
Yes.
In this legal opinion, we will not touch on also the viability of the stay and the review of judgments, especially considering the timelines.
Yes. What do you think? You know, what can you see there?
I would have to refer to my notes, but I know when we talked about when when we talked about like review, you have to do it to the same court and things like that. And then the stay, you have to pray for stay without unreasonable delay because it's at the discretion of the court. So I thought maybe we should touch on that also.
Yes.
That pending like resolutions of the decree, like, yeah, there's also the issue of stay.
You see, yes, you see, let's go to the question. On 5th August, the respondent filed an application as certificate seeking stay of execution of the decree and review of the judgment. Of course, they review the judgment based on apparent errors and the grounds for review. And these are the review on this, that the decree, they were not given for them to see it before it was signed, and the costs were not ascertained. And these people did not declare. Those were the grounds for review. Stay of execution, you must discuss the principles of it has not been brought at an unreasonable delay. There are chances of success of this and they will suffer irreparable damage. Then the respondent there on the grounds that you are not given notice of this, and they have discovered the claimant had been advanced loan while she was an employee of the respondent. And still, the application was decided before who declined to grant Italy's order, but certified the 8th agent and directed to be served forthwith, hearing inter partes. So, yes, it is very true, because the stay of execution, although it had not been given, it can be given during the inter partes hearing to prevent the stay of execution. So, you need to discuss the stay of executions, the principles that are needed for stay of execution to be granted. The case has not been brought at a due delay. The person will suffer irreparable damage. Then for review of judgment, what are the grounds of review? And for the court to give review, you need also to discuss them. The principles that you are supposed to prove before a court can give you an orders for review. And now I want to share the civil procedure rules, because all these things are there. You should understand your civil procedure rules very well. So our relevant articles and any orders are Order 22, because it's talking about execution of decrees and orders. Then Order 45, Order 40, on stay of execution. Then review. So basis of law, the law that is required. You can say that the law that the law to be applied, or that orders on execution of decree, that is judgment and decree. Then execution and decrees. That is order 21-22. Then order 40 on temporal ejections, which was not given. Then order 45 for review. Now, we go straight to order 21. Order 21-8. This talks about, of course, you may not forget, you may not, in your exams, you may not remember the rule. But please say that civil procedure, judicial review, order 53. Temporal ejection, order 40. Review, order 45. You see? At least you must quote the order. That one is, you cannot be exempted. But the rule may not remember. But remember the principle. So, order 21 rule 8. Talks about preparation and the dating of decree. 1, a decree shall bear the date of day on which the judgment was delivered. Any party in the suit in the High Court may prepare a draft decree and submit it for approval to the other parties to the suit, who shall approve it with or without amendment, or rejected without undue delay. And if the draft is approved by the party, shall be submitted to the registrar, who, if satisfied that it has been done in accordance with the judgment, shall sign and seal the decree accordingly. So this order requires you, when you are drafting a decree, you must inform the other party for them to approve. With or without amendment, or reject it. In this case, they were not involved. So that decree is null and void. You discuss that rule 8. Then on costs, you go to order 21, rule 9. you must include your cost when you're drawing a decree or when you're executing. We are told that the decree was signed and applied for execution without ascertaining the cost. So, under order to 21 rule 9, where the amount of costs have been agreed between the parties, fixed by the judge or magistrate, certified by the registrar, taxed by court, the amounts of costs may be stated in the decree. In all other cases where the cost has not in fact been stated in the decree or in order which is approved, after the amount have been taxed or otherwise ascertained, it shall be stated in a separate certificate to be signed by the taxing officer. So, relevant to this is section 94 of the Civil Procedure Act on what happens if you are not included your cost or the cost have not been taxed. Because in this question, we have been told that this decree was given. We have not been told about any cost, whether it was included, whether it was taxed. Section 94 of the Civil Procedure Act is relevant. It says, where the High Court considers it necessary that a decree passed in the exercise of its original civil jurisdiction shall be executed before the amount, of course, incurred in the suit can be ascertained by taxation. The court may order that the decree shall be executed forthwith, except so much thereof shall relate to the cost, and so much thereof as relate to cost that the decree may be executed as soon as the amount of cost shall be ascertained. So what this section says is that for you to tax, to execute your decree without cost, you must have gotten leave from court for you to proceed with execution of a decree without the cost being ascertained. And this leave is done through a notice of motion to the same court. I have a case here, an example. Which is called Mary Wagoi Karaja and another. Versus Rhoda. Be reminding me if you hear that we have started the substantive session without praying. Prayers are very, very important. Or I have not started the recording. Because the recording is very, very, very important. Mary Wagoi Karanja and another versus Rhonda Wairimu Karanja and another. You can see the case on your screen. You can see the case.
Yes.
Yeah?
Yes, we can.
You are very silent, Ruth. I can't hear you, imagine.
I'm saying yes, we can hear.
Yes, so this is if you look at this case, which is on your screen, Mary Wanjiru Karaja and another versus Rhonda Wairimu Karaja and another 2021. Before the court for determination of preemptive notice of motion, seeking the following orders. That the court be pleased to grant plaintiff applicant leave to execute decree issued against the second defendant before taxation of party-to-party bill of costs. That was one of the orders. The others are not very relevant for here. Then, the analysis and determination by the judge. The plaintiff are seeking for orders arising to execute a decree of this court dated 12 May 2020, before taxation of costs. The backlash have been brought pursuant to Section 94 of the Civil Procedure Act. The same section provides as follows: where the High Court considered it necessary that a decree pass in exercise of its original civil jurisdiction, what I quoted. What was the interpretation of the Court of Appeal in Baburi Pottery Cement versus Hussein, stating that Section 94 of the Civil Procedure Act requires that an execution of a decree before taxation leave must be obtained from the High Court. Such leave may be obtained, may be sought informally at the time of the judgment. In the question, we are not told that they sought the informally when the judgment was delivered to execute without first taxing. The question is, we are not being told, but if not done, made by way of a notice of motion. So if you don't ask informally, when the judgment is given to execute the decree, the judgment without the cost, you ask informally, or you do a notice of motion. Like here, the motion must be some of the other party and be heard at the parties. Order 21, Rule 7.4, purports to confer the registrar and the power to safely given the court under is clearly without bias. So that's what you need to do. And if you look at this case, they were granted leave to against the second defendant before taxation. So this is what you are supposed to analyze in the question. Saying that these people could not have executed without cost. And if they needed to have executed without taxation of cost, they need to have informally asked the court when the judgment was given, or seek leave to tax to continue with the execution of judgment and decree without taxation. Then when the decree was being drawn, Order 22, Rule 7, which is on your screen. Order 2, Rule 27. Oral and written application. Where a decree is for payment of money, the court may, on oral application of the decree of the time of passing the decree, order immediate execution thereof and arrest of judgment prior to the preparation of warrant, if was within the premises of court. Now, save otherwise provided under Rule 1 or by any other attainment of rule, every application for execution of decree shall be in writing. Application for execution to court by the applicant or his advocate or some other person proved to the satisfaction of the court to be acquitted with the facts of the case shall contain tabular form of the following particulars. So these are the particulars that you must include in your application for execution of a decree in court. The number of the suit, the parties, date of decree, and you may have seen them in some of these pleadings are there. Whether any appeal has been preferred, whether any what payment or other adjustment of any in the controversy have been made between the parties and subsequent to the decree. Whether any previous application have been made for execution of the decree, the dates of such application, the amount with interest, if due, upon decree or other relief thereby, together with particulars of course decree, were passed before or after the decree sought to be executed. The amount of cost, if any, awarded. The name of person against whom execution of a decree is sorted, and the mode of assistance the court is required. The delivery of any property specially decreed by attachment of sale of movable properties. The mode which you want the court to assist. Is it the delivery of the property? Is it the attachment of sale of movable property? Is it the arrest of detention or prison of the judgment delta of the debtor? Is it the appointment of receiver? Is it any relief you want as the judgment creditor must state? So the court to which application is made may require the applicant to produce certified copy of the decree. So these are all the details that that must be involved when you are applying for application for execution of a decree. So in this, when they were applying for execution of the decree, they needed to have stated that this person, Jane, was owing the judgment debtor some money, which they ought to have deducted in their judgment, so which they did not declare. Are we together? Are we together to that point?
Yes, we are.
Yes. So that is what you ought to have analyzed. Then, of course, you can. That was enough for that question because it's 10 marks. Then, of course, you can go to order 40. What Marianne, you are saying? For the application for review. No, order 40 for injunction. The grounds you need to prove for you to be given a temporal injunction. Where any suit is proved by affidavit or otherwise, that any property dispute in the suit is danger of being wasted, damaged, or annihilated by any party, or wrongly sold in the execution of a decree. Very, very important. This point I had not seen it. The court may order a temporal injunction to restrain such an act. So you can discuss on order 40. Irreparable damage. The application has been brought without undue delay. The property will be wasted by wrongful execution. Then you come to review. What are the grounds that the court gives? Is order 45 rule 1. Very common question. Of course, you can go to court for review if you have appealed. These people have not appealed. Two things you must prove: discovery of new important matter or evidence, which after exercise of due diligence was not within the knowledge or of the person. Or some mistake or error apparent on the face of record. Was there important evidence or mistake? You discuss that. You can discuss that. Order 45. Very common question on review. So, If you do that question, you have done it well. It was not a very easy question, but the main thing is decree and execution of judgment.
Mwalimu, may I ask a question?
Yes.
What are the grounds for amendment of the judgment? We covered it in class and I got confused. I know it's like something like section 99, but I'm not sure.
Amendment of judgment, eh?
Because yes.
It is to rectify small errors, eh?
Okay.
Yes, it's just to rectify small errors that could have, you see, I'm projecting 99, eh? Amendment of judgment, decree, and orders. Clerical or arithmetical mistakes in judgment, decrees, or orders arising thereof, accidental slip or omission, may at the time be corrected. You see, when the court have given a judgment, the small mistakes on cracks, maybe the calculation of sums, eh? Of how they arrive at the damages. Those one you can go to court and you amend. You can make an application for amendment and you can look at how the application is done. That is a question that can come. But if you are the substance, you are challenging the substance of the judgment, how the judge argued, you do either a review to the same court or you appeal. Are we together?
Yes, Mwalimu. And in that line,
yes.
I don't remember which paper it is. I will look for it and maybe send you a screenshot. I don't know if it's the 2023 paper. There's a question about you doing a ruling on amendment of pleadings.
Yes.
I think I don't know if we've done it. I think we did it. And the issue was about the parcel, the registration number that was issued. They did the search wrongly and they depended on what the search, I think the registrar had given them. So you were supposed to give a ruling on whether or on if that amendment should be allowed or not. I don't know if you've gone through that question.
Yeah, we did in this class.
So like in that situation, is that a clerical error or that should go for amendment, or is it a substantive issue that changes the suit and so should go for review or appeal?
You see, Article 90, Section 99 talks with amendment of judgment. You see, the judgment says that this person who said these damages, ground is culpable. Yeah, this person who paid general damages, have infringed the rights of this person. He pays these damages, general damages, 5 million, special damages, 2 million, cost. Then the decree will be drawn from the judgment. If it's a decree or orders of the court, if it is a ruling, the court issues an injunction to pending the hearing and determination of the court. That is a ruling. Then you draw an order from it. If there are clerical errors, you can go and back and ask for court to amend. But in our question here, the question was very specific, which we are dealing in this week. Which rules do you the pleadings? What question? It was question 2. The question was telling you Peter had filed an application seeking to amend his plaint. So if you are told to insert an application to draft amendments, then you are told to give the ruling as a judge. Of course, that is amendment of pleadings. But question you can be also be told to the judge gave the ruling, then you can also review to the same court or appeal. On appealing, you know there are orders which you cannot appeal from. You know that there are orders given by court that you cannot appeal from. There are orders that you can appeal and there are others you cannot appeal. You know that?
Okay, in my class, we haven't really delved into that. The only one that I know our lecturer specifically mentioned is if you get a review from, like if you get an order reviewing your previous order, you cannot get a review on that again. But like we have not covered repeat orders you can and cannot appeal.
It is here in the your civil procedure rules. Not all that you can appeal from. That's another question you must you can be asked. That's why I usually tell you civil procedure is not it's not easy. Let me find for you. I'm liking this class, the question you are asking. What you learn in the class is very, what you learn in class, it is very small, it is very, ni kidogo sana ya kukusaidia kupita exams. What you need is a lot of your hard work. Your hard work, your hours of, after we finish this class, what you go and do when you are alone. That is what will help you. Article Order 43, Rule 1. These orders, these civil procedure rules, you cannot do without. Yani you must understand it very well for you to do your exams well. Make a summary of it. Good. Order 43. I hope you can see it.
Yes, I can. Thank you.
Appeals shall lie as a right from the following orders and rules under Order 75(1) of the Act. You can, if the court gives you a ruling, for example, amendment of pleadings, what we are saying, if the ruling is against you, you can appeal as of a right. So you need to know if the question, if you have been told that it is an appeal in your civil procedure rules, remember all these orders. Very, very important question. Thank you, Marianne, for asking that question. It can come. In fact, these are not been tested. If you are told now this person is appealing on a ruling that was given in court, the first part, the question you must ask yourself is whether you have a right of appeal under all these orders. If it is not under appeal, it is a leave. It is a right. You first of all seek leave. Seek leave to appeal. You seek leave. So it is good you know all these orders. When you are told to the case, the person want to appeal, draw the pleadings on the decision that were made by the lower court. Ask yourself whether you have the right of appeal automatically, or first of all you seek leave. Three, an application for leave to appeal under section 75 shall first be made to court making the order sought to be appealed either orally, at time it's made, or within 14 days from the day such order. Have I answered your question?
Yes, you have Mwalimu. Thank you.
So, civil litigation, you need to know the orders and the timelines. Very, very important. So, you could have answered that question that way. And the highest scoring student did not answer that question. Eh? Of course, you understand that it was not easy. Tested area in the past on the execution of decree. Very popular area. Examinable area. You see why I tell you that you are in your classwork, you may not be able to do such kind of things. After the lecturer lectures on execution of judgment and decrees, you may not go to these dynamics. So it is very, very important for you to look at the past papers. And not only are we looking at the past papers, we are looking at the future predictions, future areas that can come. Notice to show costs have been tested. Mode of execution of a decree. Drawing a decree have been tested. Steps to take to enforce a decree. Drawing a decree you do when you are doing year 2008 to 2019 Q&A. Please draft when I tell you to draft this for your benefit. Even if you are two of you, do the drafting that you are going. I'm telling you, it is for your benefit. Steps to take to enforce a decree. Garnishee proceedings. Objection to execution. Procedure of attaching a movable property like land. Ways of enforcing a judgment and a decree against the a decree. Those have all been tested that they are in your Q&A. Look at them diligently. What are the answers that I've given there? Areas that have not been tested in this topic. Lifting of corporate veil in execution. I'm looking at your course outline. All the other areas have been tested. Notice to show cause, decree of payment of money, decree of specific movable property, garnishee. Garnishee, you can be told to draw a garnishee application. What do you need to prove for you in garnishee? Execution against government, you can be told to draw, have been tested. What do you need to prove? Lifting of corporate veil has not been tested. That is the only area that has not been tested under this. So look at it carefully. Draw an application to court for execution of a decree. Do an application for stay of execution that has been tested and the principles. Do an application for review that has been tested and the principles. Look at all those areas. So I think we have exhaustively tackled that question. Any question? Before I move next to next.
In that question,
yes,
if you can project it back,
yes,
of your recordings.
Sasa.
There's this aspect of the last paragraph and has approached your law firm to take over the conduct. So now I was wondering about the filing of change of advocate or the notification.
Yes. That's respondent. Yes, let me read that. The respondent is dissatisfied with the services of its advocate and approach you. law firm to take over the conduct of this man, prosecute the application. However, before the respondent advice, it requires a legal opinion on the issues raised in the application. You see, the question is specific on legal opinion on the issues raised in the application.
I understand that, but I'm just saying, can you state something like that in the legal opinion?
Yes, you can
because
state.
You have to say that they have to
do change
file
of
a change of, and notify the other party.
Yes. Yes, yes, an application to come on record. Change of name or change of advocates. You can say that. Sawa sawa.
Okay.
Yeah, you can say that. You can say that.
Mwalimu?
Yes.
In this one, I understand what Ruth is saying, because we are changing advocates after judgment has been entered. So there's the necessity for leave of court under rule, I think it's order 9 rule 12, something like that.
Yes,
you
yes.
need to also get leave of court.
Yes. Very, very important. Yeah, when the judgment has already been given, you must seek leave from court to change advocate to come on record. So that is also one of the issues you need also to raise. And that order you have said, and also go and look at for a case law. How do you approach court for leave? What is the application? I said
I would say notice of motion.
Yes, the notice of motion. But when we said when you cease from acting, use you use chamber summon. Let's confirm that.
I believe it's a chamber summons, and you need to serve this on everyone so as not to prejudice the rights of the other party and to inform them of the change.
You have a case?
Let me look through my notes. I have one.
Okay. Let's settle that one right now. It's very, very important. You have said that rule is order what? Order 1?
It's order 9, I think, around rule. The changing of advocates is usually between rule 6 and 12.
Sawa. We are dealing with a potential exam question. I can tell you we are dealing with a potential exam question. It can come. What is the order? What are the principles? How do you approach court? Can you be able to draft such a pleading or application?
So change of an advocate is order 9 rule 5, and then change of an advocate after judgment has been passed is order 9 rule 9, and it provides that when there is a change of advocate or where a party decides to act in person, having previously engaged an advocate after judgment has been passed, such change or intention to act in person shall not be effected without an order of the court. Upon application, which notice to all parties, or upon consent between the outgoing advocate and proposed incoming advocate, or party intending to act in person, as the case may be. So the case I have is Patrick Otieno and advocates versus Muhoroni sugarcane outgrowers. The court interpreted Rule 9A of Order 9 of the Civil Procedure, Order 3, sorry, of the Civil Procedure Rules repealed, which is similar to the current Order Rule, Order 9, Rule 9. According to the court, the provision is very clear. Where judgment in a suit has been passed and the change of advocate or a party decides to act in such change only be effected by an order of the court upon application with notice to the advocate on record. The incoming advocate must first and foremost obtain the necessary court order prior to taking over the matter from the previous outgoing advocate.
Very clear. And how do you?
Yes.
How do you approach court now?
That is not clear. The one that is clear is when there's an application by an advocate that has ceased to act for a party, it's done through chamber summons. There are many cases.
Where? Sorry,
where
repeat.
the application
is
where
repeat,
an application by an advocate who has ceased to act for a party.
Yeah, that is chamber summon that I said in our last class, eh?
Yes, it is.
To cease from acting is chamber summons. Some of things, you know me, I was in a law for many years as a clerk. From 2007 to 2014, I was in law firms. Those are like 8 years. And of course, 2015, I was in Kenya School of Law. 2016, kidogo, I went back to a law firm after being admitted. Before now, I get employed at Kenya Law Report. So some of these things I remember from those law firms. It's not some of these things they come from my head. I remember these things we are doing this thing we are doing this way. And that's why some of these people who are in law firms, they have a lot of advantage. Because they deal with these things every day, practically. So I'm trying to establish here an application to come on record change of advocate after judgment, order 9 rule 9. What is the pleadings that you use? I think is a miscellaneous civil application through a notice of motion. But we need to, let's settle that one. Because these are very potential area for exams. These have not been examined a lot. So it can come in November. We need to settle it once and for all. You know, in civil procedure rules, the default pleadings that you use for doing applications is notice of motion, unless the order or rules say expressly let me do this because it's taking time. I'm going to give you a substantive answer. We cannot presume things. Before our next class. Let me write here. So that one I'm going to give you a substantive answer before next class. But I want to look at order. After order 53 on judicial review, the next order there the basis of bringing application and notice of motion. You have any other question? Applications? The relevant order is order 51, rule 1. It says, all application to court shall be my motion and shall be heard in court, unless court directs the hearing to be conducted in chambers, or unless the rules expressly provide. So, all application under the Civil Procedure Act rules, any application is through motion, or unless, of course, it's chamber summons, or unless the rules expressly provide. So, reading that, we can conclude that that application to come on record after the judgment has been given under order rule 9 is through a notice of motion. But I will confirm and give you a case law next time. So I think we have exhausted that question well. We can go back to question 6. We are not going to deal with it today. There's some things I've not fine-tuned. I'm going to look at look at the application you have shared shared to me. Look at how you did. So that you can know if you drafted well. We start with Ruth. Drafting is very, very important. Unless you do it practically, you cannot be able to know the dynamics. Sharing was up because it's a skill. I can tell you, hey, notice of motion is done this way, this way, this way. But when you go to do it practically, you realize that there's is done. It is an ini. So I'm projecting your application. Republic of Kenya. Participant can now see your application. Republic of Kenya. How many minutes did you do to draft this?
Not many, because okay, there's something. Okay, I was wondering because this one was seeking leave. I was wondering what excuse can you give for why you did not file the documents on time after the tax master refused. So mine doesn't have that explanation.
It was not necessary for this question, eh? Question for 5 marks, you draft the pleading only. That comes to the affidavit, eh? In a question of 5 marks, never draft the affidavit. You just draft the pleadings, the affidavit, which now you explain you give the story. Why? But a question of 10 marks, 15 marks, 20 marks, that one you must draw a pleadings. 5 marks use around, I told you a question of 20 marks use 50 minutes. A question of 15 marks use 38 minutes. A question of 10 marks use 25 minutes. A question of 5 marks use 13 minutes. And 13 minutes are enough to draw the pleadings only. So, Republic of Kenya, in the High Court of Kenya, mysterious reference application. Any application to seek leave, it's a miscellaneous. Then, what are the parties? Applicant, who is the applicant? The applicant here is Riz. Are we together? The applicant is the one who is seeking leave to apply out of time, not Clever. So you interchange. Applicant, Liz, respondent, Clever and Company Advocates. Chamber summons dated section 11 of Advocates Enumeration Order. It is paragraph, you say paragraph 11 of Advocates Enumeration Order. And section 1A, B, and 3 of Civil Procedure Act. And order, you don't quote order 51 because order 51 is for notice of motion, the one that I've read. So you just quote paragraph 11 of Advocates Remuneration Order. Then you can also quote section 1B, which is on inherent power of court, expeditious disposition of the proceedings. I just want to know this section 1A, yes, objective of the court, duty of the court. That one is okay. Expeditious disposition of court, of cases, then duty of court. Then 3A, inherent powers of court. So that is okay. Let all parties concerned. That's how you start your chamber summons, and attend judge on chamber summons on the day of. It's not, this case is not, is for 22, not 2021. At 9 o'clock in the morning or in the afternoon or soon thereafter, as the counsel for the account to be heard on application for orders. How you draft the chamber summons, that is very, very important. That the application be certified urgent and be heard ex parte. That the Honorable Court be pleased to enlarge time within which to file a reference. That the cost of the application be the cost. Correct? Which is application is based on the grounds on the verifying affidavit of the applicant. You must say which application is based on the grounds in the verifying affidavit of the applicant, dated in Nairobi, 2022. Which is the advocate on record for this person. Approached you, this approached you. So you cannot say he's swing clever. So you are the advocate on record. You can say Ruth and Mohoro and Company advocates, then drawn by file by Ruth Mohoro and Company advocates. Are we together, Ruth?
Yes, I'm having an issue with 51. Why can't you quote 51 in chamber summons? And it deals with applications. Because if you look like order 51.1 procedure, all application to the court shall be by motion and shall be heard in open court unless the court directs the hearing to be conducted in chambers. Or unless the rules. Now, if you conduct it in chambers.
No. Let me see. You see, order 51 rule 1, it is not, you don't court direct that the hearing be conducted in chambers, or unless rules otherwise. You know, the practice I've gotten from the practice of this application, this notice of a motion, it's usually through, that's when they quote this order 51 rule 1, but in chamber summons, usually they don't quote. So, to be on the safe side, just, in fact, if you quote paragraph 11 of advocate's remuneration order, that is enough, because that is the main rule or law in which the application has been brought. All other things, you are saying section 1A, 3, 2, A1B, 3 of Civil Procedure Act is not very, very relevant, or even order 51. For example, if you are amending the print, you quote order 8 on amendment. You don't even need to say the rule, because the rule, specific rule met to remember. If you are told to do an application for review, just say order and order 45. Temporal ejection, order 40. Just quote the one. That is enough for purposes of exams. Sawa.
Yes.
So you have seen how, yes.
I had an, okay.
they look the same. Mine and hers looks the same. My only issue was the parties. In this situation, I thought that Liz Jones was the applicant because she's the one disputing the tax.
That's what I've told Ruth.
Okay, sorry. I might not have had. Yeah, okay. Then
Yes.
everything else is fine then.
Yes, so the problem with this application drafted by Ruth, I told her, is the applicant should be Liz Jones, then the respondents will be Craven Company Advocates. Then dated and filed is the one who is doing it. So you say Ruth Muhoro and Company Advocates, then drawn and filed by Ruth Muhoro and Company Advocates. So those were the main things. Other things she has quoted well. She has drafted well. And this is the essence of doing practically. You see, if you could not have done this practically, now you could not have known that. So that's why when I tell you do practically, it's very, very important. And now opening yours, Marianne. We see how you did it. Let's not presume. Drafting practically is very, very important. You may say you know something, and you realize, kumbe, when I'm doing it practically, this thing is giving me problem. When you have drafted your things, can they be sending me in advance, so that I can be able to open them ahead of class, so that I don't waste time. Waste time opening them. Yeah, this one. Have a book to do your drafting. All your drafting should be in one place. I've seen that in doing by exams document, because you refer them now and in future. You can see Live to file, time to file a reference. Republic of Kenya, the High Court of Kenya at Nairobi, initial reference application of Marianne, date the, I told you, you be dating your pre-dates the day of exams, eh?
Okay.
Yeah, because we are doing these exams, not that now that we are looking at them, eh? You are doing an exam as if you are doing it on that day. So you date the day. So here it should be 2022. Liz Jones versus Period Wisdom of care of Clever and Company, respondent chamber summons. Under paragraph 1 and 12, advocates remuneration order. You can say under paragraph 11, and I think you have advocates remuneration order. Order 51, this one you can leave it. After saying this is enough, let all parties concerned the Honorable Judge in chambers on that day of 2022 or the forenoon and soon thereafter on the hearing that the applicant for that this honorable court be placed to a large time within which to file a event that the cause of application being cause. Which application based on the foreign grounds and other grounds that being based on the hearing of that the application is premised on the grounds, among others, that the delay was a result of applicant being offices being closed due to COVID-19 pandemic. The application is supported by a various on which the applicant say the grounds on the fees of the application that the applicant has concerned the affidavit, the judgment in his ruling a taxation party to party in that case is taxed on. If you want to include grounds on the application, which is not very relevant, the easier things, this one is not very relevant. You can say which application is what the rule has said on the annex affidavit of Liz Jones. Because of time, after you do the prayers, this is just 5 marks. After you do, the most important thing is the heading, the parties, the order under which you are doing, of course, the heading of the pleading, the order. This is how they mark. Maybe this one mark, the heading, the parties 1 mark, maybe the pleading and the order in which the rule is brought, that is another 1 mark. How you have drafted the chamber summon, that another 1 mark or 2. Then how you conclude, how rules have said, drawn and filed by, to be served upon, unaona, another 1 mark. This one is not relevant. You just say, brought an application of the attached affidavit of Liz Jones and other evidence to be brought during adduced at the hearing of the application. So all these things, because of the time, in fact, you don't have time to do these things. Just for 5 marks, this was not very relevant. Are we together?
Yes, yes.
Yes, this was not, if you are given 5 marks, this was not relevant. If they were Nini, you see that they have not, this was not very relevant. You just need to do a very quick thing, an application only, or the pleadings. So, our class ends there.